Hey folks, Greg Siskind. I am back after a couple weeks hiatus. Not really hiatus. I just had things going on each week. On Wednesday nights, I've been on the road, it seems like, for months. And I actually am home on a Wednesday night, and I'm happy about that. Was supposed to be joined tonight by Robby Rubin, and I just got a text from Robby that Robby has a 2-month-old and a 3-year-old, and one of them is having a hard time tonight. So I told him, don't think about it for a second. So he'll be back another week. But anyway, I've got plenty to talk about. And as I was preparing for the show, I always do sort of like this review of the news to figure out like, what would people care about. I want to have some variety. I don't want to necessarily have just employment stuff. I don't want to have just enforcement stuff. And I think this week there's just the right mix, and hopefully you find the news this week. Well, I don't want to sound like we're trying to build it up to something that is like you're going to like. Most of the immigration news you're not going to like, but we try and make it digestible so at least you know what's happening. So the first thing, I was trying to figure out what leads this week. And, I guess that we know that other cities, I think Kansas City and Charlotte are going to be added to the list where federal law enforcement is going to be coming and trying to do their thing from an immigration perspective. But it seems like most of the headlines are coming from Chicago, even in Memphis, where I live. And we have had, for weeks, we've had this federal task force here, which in theory is supposed to be more about law enforcement than necessarily immigration enforcement. I'm not sure. I did see at my coffee place this morning a ATF officer, and I was just thinking, it's like, well, it sure is great that we don't have any issues with drug trafficking, and we don't have any issues with gun running, and all that's behind us, so that they can focus their effort on coming to Memphis, Tennessee, and looking for immigrants. And of course, I'm being facetious, but there was a New York Times headline earlier this week talking about how DHS has really abandoned a lot of their mission for a lot of the things that they do in order to divert all their resources into immigration, which kind of leads me to the first story on Chicago. There were new federal documents that came out this week. I'm looking, and this week I prepared ahead of time, and I made the cryon so I can identify each story. Isn't that great? But 97% of the 614 immigrants that were in federal documents that were arrested in Chicago under their Operation Midway Blitz. I love the names on here. They always have these big grandiose names to make it sound like they are doing something, really fundamental. And they are, but it's not what they're portraying it. But they have basically said that they're going after the worst of the worst. They're getting criminals off the streets. Well, as it turns out, out of 97% of the people that they arrested in immigration raids in Chicago, out of the 614, that's the percent that had no criminal record. So in other words, out of these 614, only 3% of that group actually had some kind of criminal conviction. So, when the administration is talking about getting violent criminals off the streets, keep that in mind, that the vast majority of the people that they are getting are people that are not violent. They are people that are not criminals. They are, and you've seen the news reports, they're going into daycare centers. They're going into grocery stores. They're going all these hotbeds of crime in Chicago. It seems to be what they're targeting. So, and that seems to be pretty consistent with what we've seen elsewhere. And it's sort of like it was a reminder that when the Biden administration came in, they had this memo that they released the first week they came in. It was similar to what the Obama administration had done, which is this prosecutorial discretion memo. And they said for ICE attorneys, this is where you focus. These are the people that you should be trying to deport. And if people are not in that category, they should be a lower priority. And actually, the reality is that they were able to deport a ton of people in both the Biden administration and the Obama administration by focusing on that. So anyway, that was the people think that they voted for the to deport criminals, and I thought it was helpful that that data has come out of Chicago. There was some data that also came out of Chicago. Well, there was some news out of Chicago actually this afternoon. There had been some court orders that were pushing back some of the tactics that ICE was using in the city, particularly on the use of tear gas and excess force during immigration raids. There was an appeals court today in Chicago that reversed a lower court ruling that had limited the use of tear gas and similar force during the raids. And those tactics are able to continue, unfortunately, now after this appeals court decision. So that was that was news out of Chicago today that wasn't great, but it's it seems like we keep going back and forth in these decisions where you never know from day to day. And there's I think it's sort of the story of the administration's immigration policy since the beginning of the second administration, which is it's just basically they do what they're going to do, and then they see what will survive court challenges. And sometimes the court challenges are successful, sometimes they're not, and sometimes it goes back and forth depending on what is the issue is. So in this particular issue, the administration has a win. We'll see if this continues. And also, this is sort of, this is one city and litigation like this is happening in the other cities. So one of the things that, I think that the courts are only one of the challenges that are being used to basically push back. There's been some interesting reporting this week coming out of Charlotte on a lot of grassroots activities that were happening, particularly in congregations around Charlotte, of training people to on how on filming and documenting and how to sort of push back in legal ways that are not going to endanger anybody. But that is that's something that we're seeing more of. One thing they were doing in Charlotte that I thought was interesting is that, for a lot of people, and this is really a sad commentary, but for is setting up food pantries. And I actually got an email about that today in Memphis, similar, but food pantries, not because immigrants can't feed themselves, but these are basically food pantries that are essentially delivery services, so that people don't have to take unnecessary trips out in public where they become targeted for immigration enforcement activities. So, we're seeing that kind of thing happening in these communities. Okay, so that was thing number one. And let's move on to a court win, since we started with a court loss. And I was happy to report on this. So a federal court partially stayed a 2024 USCIS fee rule as it applies to EB-5 cases. Now, I don't think we have I don't know how many EB-5 aspirants watch this live stream, but this was an important win. It was actually my good friend Matt Galati was one of the lawyers in the case, and I want to congratulate him. I don't know if Matt's watching, but if he is, congratulations. So basically, it was a court went on regarding the exorbitant fee that had just been imposed that seemed to be contradicting previous fee rules. So the government gave up, and they said that there would be immediate cost relief for investors in regional centers. There were fears of rejection of cases because of miscalculating the fee during this transition that they were imposing. Anyway, it was a real mess, and I'm not going to go into it except to say that it was a nice win for the plaintiffs, and it's another example of where litigation matters. Another case, and I didn't have it on my list, but I want to mention it anyway. It might have been from more than a week ago, so I don't know if it was talked about previously, but it was not. It was pretty recent, and it dealt with R1 visas, and this is another one where some clergymen had sued because of the way that the R1 visa was being interpreted to force them essentially after 5 years, when there was no green card available at the end, and some of them have applied for H-1Bs, and some of them are actually in my lawsuit that I'm a co-counsel on. And I'll talk about that before this is over tonight. But they had a nice win as well with the government. Again, sometimes it's sort of like, it's a win when the government backs down and decides to settle with you. And in this case, they came up with a mechanism to make R1 visas. I don't think this has been announced yet, but it was reported by Law 360. And I had heard also from one of the lawyers. I had posted on an attorney listserv about the case, but it looks like R1 visas are going to be similar to H-1B visas, where if you have a green card application pending in the EB4 category as a religious worker, and you run out of R1 time for the 5 years, you'll be able to continue extending the R1 visa. So that was a nice win as well in court. And there are plenty of other court cases that are in the works. I know that there's a case that's coming on the EAD extension rule that just came out that had reversed a Obama rule that I think came out in December. Anyway, I did some research as well before this live stream about these late Obama rules I'm like in a time warp. Late Biden rules that had come out in the last weeks and months of the administration, and then the question was, and I'm kind of looking at my cheat sheet, which is my research on this, but there were a few of them. There was a that have come out where there were rules that came out late. There was a public charge rule. I'm going to talk about that in a few minutes. There was an H-1B modernization rule, which had some important changes that protected certain rights for immigrants. And then there was the EAD extension rule, which I think is actually, that might have been part of the H-1B modernization rule. In any case, so what we're seeing now are these either on the regulatory agenda or proposed rules coming out. No final rules yet, but these rules are coming out which purport to basically reverse these very thorough rule. I mean, these rules that came out in the Biden administration after sort of this very thorough process that they went through to make these rules final. And the thing is, if you go through that whole administrative law process and get a rule finalized and you've done everything exactly the correct way, it's not supposed to be easy for the next administration just to completely reverse. So that was that's what we were seeing with some of these rules that have come out, and they're being challenged when they come out, but they're going to be very ripe for litigation when it happens. So the EAD extension rule, that's a really easy one probably as far as to challenge, because the rule was finalized only December 2024, I think, for the rule that they're now completely rescinding. And they have to show that, they can't just say, we don't like this rule. You can't do this. You can challenge rules based on, this concept of regulatory whiplash. backlash. And that was actually something I enjoyed reading about when I was doing the research for this little segment. But basically, the Administrative Procedure Act has provisions that apply a standard of you can't implement new rules that have been applied with an arbitrary or capricious in that particular manner. And that was in the first Trump administration. It was very possible to do that. You also can't implement a rule just to be mean. That's you can't do something with animus on there, and that's been successfully used to challenge certain administration actions since it came out. So Congress could have reversed these rules under something called the Congressional Review Act, and the Republicans had the majority, and there was some rumors that they were thinking about doing this stuff. But alas, the deadlines have passed, so you can't. I think you had until mid-May for Congress to basically, by a simple majority, they could reverse a rule that was done in the Biden administration. The fact that they didn't reverse doesn't mean that you can't do new rulemaking in that space, but it certainly means sort of the easy way out for the Republicans would have been to do that, and they didn't. So now they have to deal with that. Anyway, that's those are a few cases that you can be on the lookout for. As far as this would be probably a good time to mention a little bit about the H-1B case. I know a lot of people are still getting they're basically facing day-to-day challenges on that. So just to kind of give you guys an update on what I can say, and some things I can't say because I'm a lawyer in the case, and so we don't want to just like broadcast on a live stream to the Department of Justice lawyers what our strategy is in the case. But what I can tell you is that there are two cases that have been filed to date. One is our case called Global Nurse Force versus Trump, and that's filed in the Northern District of California. And that is the case that we have a mix of employers. We have beneficiaries like workers, and then we have unions in our case. And that is a little bit different than sort of the makeup of the other case that's been filed in DC by the U.S. Chamber of Commerce and joined later by the Association of Universities. Forget what their acronym is, but that case has a lot of similar arguments to our case as far as the which is good because I think our arguments are strong and they're probably strong in that other case, and honestly we'll be happy wherever the winds come. That case is not filed as a class action, so it may be the case that the universities that are members of that association, as well as employers that are members of the Chamber of Commerce, would benefit from their win, but not employers that are not. And I don't know what it costs to join the Chamber of Commerce, but my understanding is it's fairly expensive. So I see a win in that case as being important and influential. Probably if they get the first win on this, it'll help our case. But we are, we are working on the class action question as well as the preliminary injunction. I'm not going to say any more than that, except that we will have some news soon, very soon, on the next set of motions that are coming, where there might be some additional plaintiffs. I can't mention, anything specific, but what I will say is just keep an eye on over the next couple of weeks, and there'll be action. There should be some important action in the Northern District of California case. There is also, my understanding, another case that may be happening in the northeastern U.S. That may be coming from the government, some blue states. I don't want to say more about it than that because I don't know what I am authorized to say, but that is, so there might be a third case. That's an important one. And then I've heard of about another case that might be filed by some individual immigration lawyers who have a lot of experience suing in mass actions. And I don't know where they're going to sue, but I know that they have been soliciting plaintiffs. So anyway, those are, that's what's happening there. My expectation is probably December is going to be a very busy month for the two cases that are there. I'm guessing we're probably stuck with this provision into the month of January, but it's very possible that that we could have at least some decision before then, and we will see. Okay, so let's move on. I want to talk about the Supreme Court has decided to, and I know there was from some of my friends in the immigration bar, there was a collective groan at the news that the Supreme Court might be accepting review of a Ninth Circuit decision. A Ninth Circuit is the west coast of the U.S., including Hawaii, concerning CBP's former metering policy, where they would turn people away at ports that have legally arrived in the U.S. for asylum purposes. In that case, there will be arguments probably in early 2026. So why does this matter? It matters because it could reshape access to asylum at ports of entry. There's a it's a key part of the administration's border policies, and it is it's something that the administration would like to get a win on that, just to affirm that their policies that they have right now are legal. Anyway, it could have, the Supreme Court decision on this could have impacts on broader asylum policy, which in a lot of respects it looks like the administration is not following international law, not following U.S. Precedent, and we'll see what the Supreme Court has to say about it. Okay, so Venezuela, after so TPS has been allowed to terminate for Venezuela. At this point, the Supreme Court is kind of allowing this to happen despite some wins at the lower courts, even after the Supreme Court's decision. I'm only mentioning this week because USCIS published I-9 guidance regarding benefit eligibility, and basically the policy matters too because it's they have to change these the language in these guidances in order to be consistent with what the courts are doing. It impacts a large Venezuelan workforce, and their employers, are about 500,000 of them here. So just kind of keep an eye on that. But employers of Venezuelans really kind of need to follow the I-9 guidance on the website if they're going to insulate themselves from liability, even when the courts are moving on it. I tell employers it's fine if you want to make legal arguments, but really you need to follow the I-9 guidance in order to know what you're supposed to do, including with employment authorization documents about whether you can accept them or not. So that's all I'll say on that. I'll move on to the fifth story I had, which is that another third country transfer agreement has been published by DHS. These are the agreements with these random countries that have agreed to accept people who are from other countries that the U.S. chooses to deport and are not able to deport back to their country of origin. So they have this bilateral agreement allowing certain asylum seekers in the U.S. to be transferred to Ecuador for processing. There are a lot of due process concerns, humanitarian concerns about these offshore transfers. There have been allegations of human rights abuses already by some of the people that have been transferred to places like El Salvador and South Sudan. There's likely going to be litigation over the scope and the legal sufficiency of these kinds of agreements, and immigration lawyers are going to have to assess who might be subject to these transfers, and are going to have to advise clients accordingly. But once again, another country added to that list. Okay, so I said before we're going to talk about public charge issues. So one of the things that's coming as the Department of Homeland Security has issued a notice of proposed rulemaking proposing to rescind the 2022 public charge regulation and reinstate this broader framework for evaluating financial risk. So if this sounds familiar to immigration watchers, it's because the administration tried a very similar rule in the first Trump administration, which eventually got tossed by the courts. So they are, once again, bringing back uncertainty to how the public charge rule works. By the way, it was a interesting exercise for me. That was when I had started working on AI apps, expert system apps before, and I don't even think people even think these things are AI anymore, but these expert system apps were essentially, I would build out these apps that were sort of web interviews that were decision trees, essentially taking you down different paths. And then the AI app, the expert system, these old school apps that basically then generate a memo for and this was these were designed for lawyers. They were designed for the public. We did them for public and we did them for like travel bans. We did them for the various benefits that were coming out and various bans that were coming out. But anyway, one of them I did, and I took an entire week off of work. There was a 300-page regulation that the Trump administration had issued on public charge that was going to make a very sizable portion of the immigrant population that was trying to legally obtain a green card or other benefits, was going to make them ineligible based on this belief that they were going to become a burden on the public financially. So I built out, I really kind of had to dive deep into this regulation and sort of map out question sets to figure out whether people were subject to it or not. And I came out with this app, and it was I made it free, available mainly in the immigration bar was the main people I had made it for. It was fun to work on that. But I was tired at the end of that process, and I said I will never do that again. Happily, with generative AI, I can take those question sets and basically just tell it to follow the regulation itself and give it some guidance and build out a really good prompt, and maybe do that entire app now using generative AI in a fraction of the time to actually create that. But I'm actually hoping that that's never necessary, because this rule will never actually see the light of day, for much of the same reasons that it failed the last time. And it's sort of like any lawyers that want to sue when this rule comes out, all they need to do is find the litigation from 7 years ago or whatever it came out. I think it was 2018, and there's already basically a pathway designed for how to challenge it, because the administration's already lost on this, which makes you wonder why they're doing it again. But there's going to be a comment period, and it would behoove everybody, lawyers and non-lawyers and access to justice folks and nonprofits and everybody else, to file comments on that rule, even though we know the administration generally is going to ignore the comments. They matter to a judge when these rules are being challenged, if you can show that they were overwhelmingly opposed and they decided to pursue something anyway. Okay, there was something that was related that I also wanted to talk about that went into effect immediately, and it's not just a proposal. So the Department of State issued this new cable, which is basically a memo that Washington sends to all the consulates around the world, telling them to essentially apply a new public charge directive. So this cable is telling consular officers to apply more expansive negative factor analysis in public charge determinations, looking at things like financial self-sufficiency, looking at the scrutinizing the documents they're presenting, looking at the civil records that they're presenting and the reliability. This is not just for this is for non-immigrants and immigrants. It takes effect immediately. It binds officers now. It's going to potentially increase visa refusals for like I said, both immigrant and certain kinds of non-immigrant cases. And it is also creating an inconsistency between State Department and USCIS public charge standards, which itself could potentially lead to litigation. But anyway, it is something now that you're going to have, if you're consular processing, you're going to have stronger financial documentation as a matter of course in those cases. Otherwise, you might find yourself being denied for this reason, even though you're seemingly qualified for everything for the visa, and you've had USCIS already given approval, and you've done everything correctly, and then you have the State Department saying, nope, we're not going to let you in because we think you're not going to be able to keep yourself over the poverty line once you get to the United States. So be prepared for that. And just, the best I can tell you for right now, until one day when somebody litigates this, is that you are going to, you need to be prepared to address that issue ahead of time. Okay. So there's apparently the New York Times was reporting this travel ban, country-specific factors might be used in green card applications in the United States. So according to the reporting on internal draft memos that are circulating, USCIS might adopt a policy of treating these country-specific indicators from the 2025 travel ban proclamation as, quote unquote, significant negative factors in green card and humanitarian adjudications. They haven't given any more formal guidance, but this is an attempt basically to extend the travel bans that were announced in June, not just to entries into the United States, but to adjudications that happen for people that are already here. The best I can say about this is, boy, is this illegal on there. It's if they decide, first of all, it wouldn't surprise me if this is the fact that this is being leaked, and New York Times is reporting on this thing leads me to believe they were trying to implement this secretly, which itself is a problem. They have to actually go through a publication process. You can't just implement secret memos like this. Second, 212F is the basis for the travel bans that were implemented in June. The section Immigration Nationality Act, Section 212F, which allows the president to bar the entry of individuals or groups if they can demonstrate that it's in the interest of the country to bar their entry. Now, I've said the word entry several times already in this discussion, and that is because that is where the power is limited. So the president can bar entry of people that are subject to it. They have to give a reason for it. They have to provide for exceptions to it. So all of that is fine, maybe, for the entries that were in June, even though there's some problems with that, and there's some litigation that's coming in with respect to those cases. But that doesn't mean the president gets to start extending the bans to things other than entry. So, for example, in the first Trump administration, there were a variety of bans on that had to do with the COVID the pandemic, where they were barring entries of people from certain countries after there had been a COVID outbreak in that country, and they said we were going to ban entries from all the non-immigrants in whatever categories for people that are coming from this particular country, and they would say you couldn't be if you were in this country in the last 2 weeks before coming into the U.S. you can't come. So what they then extended it to was they said, okay, well, this policy exists. So the State Department, which doesn't do anything about entry, all they do is issue visas. CBP deals with entry at the airports and the southern and northern borders. But the State Department said, we're not going to issue visas because these people can't enter the country anyway. So why bother on there? But that's not what the statute allows. The statute only allows the barring of entries. And as it happens, there were lots of fiancés. We did 6 of these cases who said, you know what? I'm happy to send my fiancé to another country that's not where there's no COVID outbreak and have my fiancé stay there for more than 2 weeks and then have them enter from that country. And the administration fought us on that, and they lost 6 times. 6 different courts they lost on that issue because it was the judge had deemed it's like you can't ban visas, you can only deal with the entries. So they lost on that issue, and I think the same principle will apply here, where somebody applying for a green card that's already in the United States is going to say, the administration is exceeding its authority. They can ban entries, but only Congress can actually, for as far as applying these factors and denying people for these other reasons, you have to show that they are not eligible for the green card for one of the reasons that Congress put into the Immigration Act, which is not what this policy apparently is going to do. So I am expecting that this policy will not survive very much longer. If it does, I imagine there will be litigation, and that's the thing. It's like always, you can almost always assume there's going to be litigation. The main question is who is going to be taking the case on and where they're going to file. Okay, next. So there were the Forbes, Stuart Anderson, who's a great commentator and analyst on immigration issues, has did a good story in the last couple of days talking about it's not really breaking news per se right now, although, well, I don't know when it came out, but basically the administration and every administration, they publish these regulatory agendas saying sort of like what's coming as far as rulemaking that they're working on. And Forbes, Stewart's story in Forbes reported that DHS is going to try probably next year, early next year, to issue a rule targeting F1 OPT, optional practical training, and either limiting it or eliminating it entirely, tightening STEM for regular OPT, tightening STEM OPT eligibility, employer compliance, field of study, basically making OPT much, much harder to use. So, that is a fairly concerning piece of news, even though it's they haven't even proposed the rule yet. But the fact that it's in the agenda that they're working on that should make companies really nervous. It's OPT is really central to the U.S. talent pipeline. This is going to affect universities, employers, innovation sectors. A lot of people would not come to the United States in the first place if OPT was not available. That's an important thing that makes the U.S. foreign higher education system attractive. I'll get to that story next as far as what's already happening with student enrollments. It could push graduates to be, into the H-1B lottery a lot earlier. So the denial of H-1Bs is going to be more of a concern. But anyway, institutions, employers, they need to start thinking about this and preparing for when they can start writing comments on this kind of thing. But I did want to let people know that it's coming. And so the last story I had on the list is what I was just talking about, which is international student enrollment trends. So the Washington Post issued a report this week where they did a kind of a deep dive data analysis showing a 17% decline in new international student enrollment for the fall semester that we are in right now. Overall numbers have been relatively flat for students that are already here, appear to be like, trying to finish their studies and they're not transferring out. But we have seen that decline in new enrollments, and some of that might be because visas are being denied. Some of that might be because students are choosing other countries. It is something that is not unprecedented. The precedent is the first Trump administration, where we saw a similar decline in student visas that started to really pick up during the Biden years. But it does have an impact on the economy. It has an impact on the institutions themselves, which I wouldn't be surprised to see in the next 2 or 3 years some schools essentially going bankrupt because they really need the foreign students pay full freight. They're not coming on scholarships. They generally pay the entire cost of their tuition, which subsidizes American students. So not only do I think we're going to see this trend continue if the policies stay the same, but I think Americans are going to really feel it in their pocketbooks when they see their kids apply for financial aid at schools and find out that there's no scholarship money available. Everything is going to have to be loans, which are already outrageously high as far as student debt. So, and then the administration is taking away a lot of the student loan programs. So, that's a policy that hits the American middle class pretty squarely. I don't think most people in the middle class associate foreign students as something that most American students probably don't associate foreign students as people that are essentially underwriting their education, but they are. And that's something that we're all going to have to keep an eye on. Okay, so there were a couple of questions. You're welcome to ask your questions. I'm sorry I haven't been answering them as I've been going on. But there was a question about the F1, and this is a good question to have. Any updates on the impact litigation? So the 60 days of getting served, they have it's not 60 calendar days, but we are getting close to this case moving, and I should have some news on that soon. I might have Chuck Cook or Jesse Blesser, one of my co-counsel, on to talk about that case, but that was filed in DC. And yeah, that case, we're going to see some activity on that. I think mostly what's happening now in a lot of these cases is the government is filing motions to try and get extensions because of the government shutdown, and saying that they should get extensions because they were not able to work in the same way, and the courts weren't able to work in the same way during the shutdown. Generally, I think we're going to oppose those kinds of motions on there, but that's one of the things. So, yeah, we should have some news to report on that case fairly soon on there. But we're not. We have not gotten the government response yet, but that should be coming fairly soon. And Todd, Tarir, I think you're the only question that I have for this evening. So I'm going to end there. I'm not actually sure who's going to be joining me next week. It might be Robby coming back. I don't even know if Robby might be watching. If you are, Robby, I hope Teddy's doing better. Otherwise, it's good to be back, and hopefully, maybe I always keep my fingers crossed there'll be some good news. So we will see between now and then. Oh, I know there was one good piece of news, and I debated whether to put it in or not. But Donald Trump gave an interview to Fox's Laura Ingraham in the White House this week, and he went off script. I wish I could find this. You can, if you Google Trump, Ingraham, and H-1B, which I'm doing on my other screen as we speak, you will see the videos of this interview. One of the headlines says, on TV, Trump suddenly turns pro-immigration, says U.S. needs to bring in foreign talent through the H-1B visa. And it's it was pretty amazing on here that he went really off script, saying that we don't have enough talented people in the United States. It looked like Ingraham, who's obviously pretty friendly with the president, got a little nervous that the president seemed to be going off script and kept trying to drift him back, push him back, saying, "Didn't you say this? Didn't you say that?" And he was like, I think he forgot what the talking points were and just kind of like actually went with his gut on there. So that is that was a fairly amazing interview, and I would suggest watching it. Does that change anything tomorrow? No. Is that maybe evidence that the president doesn't really believe what he put into this proclamation? Maybe. But it was I said I was going to be looking for good news where I could find it, so I will classify that in the good news department, along with the win in Macalatti's EB5 case this week and the win in the R1 cases. I'll put those in the good news categories as well, and hopefully I'll have more next week to report. So I am going to end there, and it's nice being back. Next Wednesday will be right before Thanksgiving, so I'll get to give my Thanksgiving greetings to you guys next week. But in the meantime, it's just pay attention to your mental health and think about all the good things going on in your life. And even though I report on all the bad immigration news every week, hopefully you'll have a little optimism about other things. So I will see you next time, and take it easy, everybody. Bye-bye.